Judge Piet Koen has dismissed former President Jacob Zuma's bid to have State Prosecutor Billy Downer recuse himself from his arms deal corruption case. The judge upheld his previous ruling on the matter, citing that there's no merit in granting the application as it will delay the main trial unnecessarily. The former president is facing corruption charges relating to a multi-million rand arms deal. Zuma accuses Downer of being biased.
I accordingly conclude that an appeal, and hence an application for leave to appeal in respect thereof, should not be entertained at this stage of the trial against the two accused. If that had been the only issue in the application for leave to appeal, I might have been disposed to granting leave to appeal on the basis that the law might be uncertain on this issue. However, even assuming and proceeding on the basis that it is accepted for the purposes of this judgment that the dismissal of the special plea is appealable at this stage, I'm satisfied that the application for leave to appeal should nevertheless be dismissed on the basis that it lacks reasonable prospects of success.
Let's reflect on those developments. We're joined by Benedict Phiri. He's a legal analyst. Mr. Phiri, thank you very much for joining us. Was it always obvious to you which way this would go? Did this come as a surprise?
It did not come as a surprise in the sense that, on prospects of success from a legal test perspective, it was always clear that Judge Piet Koen was constrained by decisions of higher courts on similar matters, on the facts and on the test for title to prosecute. I think there was a little bit of a feeling that maybe the former president would be able to sneak it in on, the question that is undecided or unsettled in the law around appealability. But as you're hearing there in that clip, Judge Koen saying, well, even if it was appealable at this stage, the overriding criterion is prospects of success, in which event he found, and I think that correctly so, that there are no prospects of success in this matter for the former President Jacob Zuma.
The trial, according to Judge Koen, will get underway on the 11th of April, come 10 a.m. Before that, though, what other options, if at all, are available to the former president?
Well, we'll probably see him petition the Supreme Court of Appeal to see if they might hear this matter, notwithstanding Judge Koen's decision. But that shouldn't have an effect on whether the trial will go ahead or not on the 11th of April. So, even if he does take those steps, I expect that the trial will still proceed on the 11th of April.
In my very simple thinking, I wonder why it is that it's the same judge that gets to decide on the matter?
Well, that's really how, when you bring an application for leave to appeal, you go back to the same judge. And really what you're trying to convince him is, I don't think that you decided this correctly in this particular area or these areas, or you overlooked a material fact, or you did not apply the law correctly. And you have to really convince the judge to, look at the matter afresh and say whether another court will come to a different conclusion. And it's a really strong test. And in this particular instance, I don't think Judge Koen could have come out with any other conclusion, given the decisions of the Supreme Court of Appeal on the same principles that are binding on him. He has to follow them whether he likes it or not.
Help us understand this, please. So a few weeks ago, when Advocate Dalimpofu was arguing before Judge Koen, he made mention of this, that if we're equal before the law, let's be equal before the law. Let's not have Zuma law. Let's not have laws that are uniquely reserved for him. Do they have an argument here?
Certainly there's no argument from my perspective. I mean, the law relating to title to prosecute is applicable to everybody. So that cannot be put in a Zuma law category or any other category. I think the gripe that the former president had was that the judge fixed dates for the filing of affidavit in respect of the application to bring further evidence in the context of the appeal. And at face value, that looks irregular because that's not the case. An application for leave to appeal doesn't involve affidavits and doesn't involve the filing of affidavits. But the judge clarified that, he was misconstrued. And I mean, this was even ventilated at the hearing. Once that became clear, then there was no basis for the complaint that the former president was being treated differently in the context of this leave to appeal compared to everybody else. So I think that complaint was really dealt with decisively in the hearing itself, and certainly when Judge Koen gave reasons for his judgment today as well.
So Advocate Billy Downer will be kept on the corruption trial. That's according to Judge Koen. And I wonder, though, whether, the NPA feeling victorious now and feeling vindicated now, does this do anything in terms of, the opinion or the public's opinion and how they see Mr. Koen's involvement in the trial?
I think, if anything, if careful attention is really paid to his reasons and they are given due weight, then I think, it will be, Judge Koen's presiding over this trial is a good one. The judgment was well reasoned. It draws on the proper legal principles and from cases that have gone before, with due reference. So I think, his custodianship and his stewardship of the matter really has been strengthened from my perspective in how he has handled this. And, it's a fine legal point, what was being argued here. So it might not translate for the general public, but certainly as a legal practitioner, it's very clear that, question around title to prosecute is not the same question as bias and whether somebody should be stripped of the ability to prosecute because of bias. And that was not how the matter was argued. But the former president may have another chance at the end of the trial. Let's see how that goes if he decides to take that opportunity at that time.
The former president has always said that he wants to have his day in court and come the 10th or the 11th of April at 10 a.m. if there is, no other move from his side in terms of, trying to not get to that date, whatever legal means are available to him. So what do you perceive then, or maybe talk us through what happens come the 11th of April?
So, yes, I expect the trial to continue on the 11th of April, even if he does petition the Supreme Court of Appeal between now and then. We will see, I think it was Patricia DeLille who was the first witness on the state's list. I expect her to be in court, and I expect her to commence the leading of evidence against the former president on that particular day. And then obviously the other witnesses will follow from there.
Thank you very much, Mr. Benedict Phiri. He's a legal analyst, for helping us make sense of this morning's developments.